Hello, I'm April Brown with Zelken Financial Services, LLC, and I'm back with today's illuminated point. So today I want to talk about will versus trust. That's right, will versus trust. So in recent weeks, I have been having this conversation around will and trust and why they're important to your overall retirement plan. And keeping with this, I keep harping on the 5 lives of retirement. Well, that's where estate planning is part of the overall plan when you think about the 5 lives. It's very important. So if you don't have your estate plan portion figured out, then your family could have some difficulty after your death. So before I talk about will versus trust, let's define what each is. So what is a will? It's better known as the last will and testament, and it is a legally prepared and bound document that states your intention for the distribution of your assets and your wealth after your death. So in the event you have children, a valid will also allow you to designate who cares for them. So actually there are 9 different types of wills. 9. So the first one I'm going to define is called a living will. This is called an advanced healthcare directive. So a living will is good for the end of life planning and to make your wishes known regarding your medical care in your future or what you may want in your future. The second one is called a testamentary trust will. So what is that? It's a will trust, or as known as trust under wills. So they're written inside a will and can be used to direct asset distribution after your passing. This type of trust differs from other trusts that it isn't actually formed until after your death. Number 3 is called a pour-over will. Pour-over wills work in conjunction with your revocable living trust. They are designed to offer more privacy than any regular last will and testament. And they work by pouring over any assets that don't directly go to a beneficiary in your trust after you pass away. Number 4, a simple will. They're simple that they don't contain a lot of clauses. You can do much of your basic planning in a simple will. I'm including designating guardians for your minors and appointing an executor. Number 5, a joint will. So a will within one document for 2 people. So you use in cases where spouses want to initially make each other the beneficiary after one passes and then establish a final beneficiary or beneficiaries being a child or children once both partners are gone. Number 6, a deathbed will. That's made on the deathbed. And so most of the time under duress, and there are often questions about the mental stability and how comprehensive a deathbed will is. So not as effective as other wills. Number 7, online wills. It's a fairly new concept in the world of estate planning. You need to be careful about doing a DIY online company you use to create your will. You want to make sure you vet the company. Number 8, they call it a holographic will. Rare, but it exists. So meaning it's a handwritten will, and they're typically the result of extreme unexpected circumstances such as war or another life-threatening situation. They're not common. Number 9 is nuncupative will, a verbal explanation that expresses final wishes. A nuncupative will are not necessarily recognized in every state, so just be aware of that. So what do all wills have in common? Well, there are 5 things. They have an executor. So basically when you name an executor, you're determining who will be in charge of making sure your wishes expressed in your will are followed. You have 2, guardianship. So for parents, you're appointing a guardian is often one of the biggest motivations of establishing a will. So the peace of mind that comes in knowing you selected the best person possible to look after your children is priceless. Number 3, assets. A will establishes where and how your assets or personal property goes to your heirs. So it gives you the opportunity to specify who gets what from your estate. Number 4 is real estate. So any building or structure or home that you own at the time of your passing is considered real estate. And the final piece is number 5, which is your final arrangement instructions. So you're specifying funeral arrangements and your wishes for your remains to be part of your estate planning. That's what all wills have in common. So if you have any sort of savings, investment, property, or dependents, you should absolutely take the time to create a last will and testament, because everyone needs to know your wishes. So let's talk about trusts and what they are. A trust is better known as a trust fund or a trust account. It's not only for the rich or wealthy people, please be aware of that. It's a legal arrangement to ensure your personal assets eventually go to specific beneficiaries. So just think of trust as a fiduciary arrangement that allows a third party or a trustee to hold assets on the behalf of a beneficiary or beneficiaries. There are 3 categories of trust, meaning different trusts will fall into one of these 3 categories. So the first one is known as living or testamentary. It's a written document in which an individual's assets are provided as a trust for the individual's use and benefit during their lifetime. So a trustee is named, and when the trust is established, this person is in charge of handling the affairs of the trust and transferring the assets to the beneficiaries at the time of the grantor's death. Next category could be revocable or irrevocable. So a revocable trust can be changed or terminated by a trustor during the person's lifetime. Irrevocable trust, as name implies, it cannot be changed once it is established. Third category is funded or unfunded. So a funded trust has assets put into it by the trustor during their lifetime. An unfunded trust consists of only the trust agreement with no funding. So that's the 3 categories of a trust. So there are quite a few different types of trusts that fall into those 3 categories. So I'm going to talk about a lot of stuff. Well, I'm going to talk about. So these are some of the common ones and some of the ones you've probably heard, and maybe some you haven't. Credit Shelter Trust, sometimes called a bypass trust or a family trust. This trust allows a person to bequeath an amount up to but not over the estate tax exemption. So the rest of the estate passes to a spouse tax-free. Funds placed in a credit shelter trust are forever free of estate taxes, even if they grow. The next one is a generation skipping trust. Yes, just how it sounds. So this trust allows a person, you, to transfer assets tax-free to beneficiaries at least 2 generations their junior, typically their grandchildren. Another type of fund or trust fund is a qualified personal resident trust. This trust removes a person's home or vacation home from their estate, and this could be helpful if the property is likely to appreciate significantly. Then you've got an insurance trust. This is an irrevocable trust, shelters a life insurance policy within the trust, thus removing it from a taxable estate. While a person may no longer borrow against the policy or change beneficiaries, proceeds can be used to pay estate costs after the person's death. A qualified terminable interest property trust. A lot of words. So this trust allows a person to direct assets to a specific beneficiary or beneficiaries, their survivors, at different times. So in the typical scenario, a spouse will receive a lifelong income from the trust, and the children will get what's left over after the spouse dies. A separate share trust. So this trust lets a parent establish a trust with different features for each beneficiary, i.e. children or child. The next one is called a spendthrift trust. This is the trust that protects the assets of a person places in the trust from being claimed by creditors. So this trust also allows for the management of the assets by an independent trustee and forbids the beneficiary or beneficiaries from selling their interest in the trust. Charitable trust. So what is a charitable trust? This trust benefits a particular charity or a nonprofit organization. So normally a charitable trust is established as part of an estate planning and helps lower or avoid estate and gift taxes. A charitable reminder trust funded during a person's lifetime dispenses income to the designated beneficiary, like children or a spouse, for a specific period and then donates the remaining assets to the charity. Another is a special needs trust. So this is what it sounds like. This trust is meant for dependents who receive government benefits such as Social Security, disability benefits. Setting up the trust enables the person with a disability to receive the income without affecting or forfeiting government payments. Blind trust. This trust allows a trustee to handle the assets in the trust without the beneficiary's knowledge. This could be useful if the beneficiary needs to avoid conflict of interest. Totem trust, also known as a payable on death account. So this trust is created during the trustor's lifetime, who also acts as the trustee. It's generally used for bank accounts. Physical property cannot be put into this trust. Know that. The big advantage of this is the assets in this trust avoid probate upon the trustor's death. So it can be established simply by having the title on the account, including identifying language such as in trust for, or payable on death to, or as trustee for. So now that I've defined will and trust, let's talk about what makes them different and why. So this wills and trusts actually overlap because they tell you who receives what assets. Other than that, they operate very differently and provide different protection for your assets. So what are the differences? Well, I broke it up into pros and cons. So we're going to talk about wills first. So for wills, the pros are you can make a will for free. You can do it yourself. It's easy to make changes. It helps loved ones settle your estate after you die. What are the cons? Just remember this. The cons are probate court. If you have a will, you can sometimes go through a lengthy probate court process after you die. So what does that mean? What does probate mean? Basically, it is a court-supervised proceeding, and it depends on how solid your estate plan is, which determines how long it takes and how much it's going to cost you. Another piece about wills in terms of a con, which is that they become public record after your death. Also, it can't protect your assets from creditors, and you can't avoid estate taxes. So, in effect, know this, that wills do not go into effect until the moment you pass away. It's just a con. So what are the pros of trust? If irrevocable, can minimize estate tax. You can also avoid probate court. It offers a greater control over when and how your assets are distributed. It can apply to any assets that you hold inside a trust. It comes in many different forms and types, and a trust goes into effect the moment you sign and fund it. The cons are that it's expensive to create and maintain. The legal assistance usually needs to be established. It is irrevocable. It is impossible for you to change after you've created it. Now that you've heard the pros and cons for each, which is better? Deciding which is better depends on your estate planning goals and on several other factors such as your estate planning budget, the size of your estate, whether you'll need access to the assets in your estate before you die, the complexity of your distribution wishes, how many beneficiaries you have, and the types of items you're dividing. That's just to name a few. And so There's plenty of information on the internet to help you dig deeper into this topic, because it's a lot when I looked into it. And so just remember, I'm going to harp on this, the 5 lives of retirement. Estate planning is part of the overall comprehensive plan. So do something, because it's important to protect your assets and yourself. So please like and subscribe to my YouTube channel. I am April Brown with Zelken Financial Services, LLC. I hope you got something out of this, and until the next time, have a great day.